Taking up today employee compensation insurance, or in other words, what you call it as workman's compensation insurance. Let's understand the object of this policy, why this policy is required. In fact, workers' compensation insurance protects employees and organizations against lawsuits related to employee injuries. Whenever there is an injury to any worker or to any labor or to any employee, they have got a legal right. So the law protects them. But this law will go against who? Against the employers, against the organizations, because they are the authority to provide and to compensate these laborers. So the object is to compensate the laborers against injuries. This insurance acts as the safety net for both the employers and employers. Employee and employers both are protected. Why? Because when this act is applicable, Employers Compensation Act 1991. When this act is applicable, the employer better knows what is his limitation, how much compensation he has to pay in case of any injury or disability or death to the labor. So employer is also on the safer side. And when you know the amount is bulky, amount is huge, he cannot pay out of his pocket, then obviously he has to plan for the risk transfer. And the best way to risk transfer is to take the insurance. Let this risk be transferred to the insurance company in lieu of certain amount of premium, and the insurance company will pay the compensation, whatever amount is awarded by the courts. It may be 10 lakh, it may be 20 lakh, and whatever it is. So the employer or the organization is free because the liability has been shifted to the employers. Now, many policy providers provide coverage for temporary and contract employers too. There are certain temporary employees like laborers in case of civil constructions. They are working on the daily wage basis also. So for such workers, there is no protection at all. Even if they get their body parts disabled, there is nobody to compensate them. Or when they die during the working hours, they have no source of getting compensation. So to provide protection to such workers, this is the act which is protecting their legal rights and compelling the employers or the organizations to take the protection by way of insurance so that the compensation can be provided to them in case of any injury or any disability. That means the workman compensation insurance also covers death benefits in the event of an employee's demise during employment. If the worker dies, how his family will survive? That is the important question. Because the government is not going to support his family. Government is not going to support even to pay the compensation to that worker. It is the duty of the contractor or the employer or the organization who has engaged that worker, and if during the working hour the worker dies, the compensation must go to his dependents. And this act provides that the compensation for death benefits in case of the employee's demise should be paid as per law. So even when an employee is unable to work due to injuries or illness, the policy covers their monthly wage until they return to the workforce. Simultaneously, the employer might have to pay fines and penalties for not having a workman's compensation policy, which can be expensive for the businesses. As such, the law is not imposing any penalty because the employee's compensation insurance policy is not mandatory as per law. But without taking that policy, employer is not in a position to pay the compensation as per the provisions of the employee's compensation insurance. So he cannot afford to lose it. He has to take the policy. There may be industries, factories, or organizations where casualty is a routine. Every year, one or two casualties are taking place. In such a case, the compensation is heavy, because even a single application filed before the Commissioner of the Workmen Compensation without defending the case by the co-advocate, the Commissioner will award the compensation as per the provisions of the law, because there is a schedule. Amount of compensation is settled already, means it is already worked out. He just has to issue the order, and the order is unchallengeable before any court of law. It is the duty of the employer to compensate or to pay the compensation through the Commissioner of Workmen Compensation Court. So this is one of the statutory obligations. That is why this policy is required. So this act is also called as Social Security legislation. Employee Compensation Act 1923 is one of the important social security legislation. I was just imagining this is more than 102 years old act. 1923. Today it is 2025. The same act is continuing with certain amendments from time to time. But this is required for the social security of the laborers, of the workers, of the employees, because this aims to provide financial protection to workmen and their dependents in case of accidental injury by means of payment of compensation by the employers. Even when there is no employer, there is only contractor. It is an obligation on the contractor to pay the compensation. If he has not taken the policy, he has to pay out of his bucket. Because this is the social security problem. A laborer and his family cannot survive without getting the compensation in case of permanent death or disability, permanent disability or death or even injury. This is important. Now there are certain important findings, like the name of the act has been changed. First of all, it is no longer known as Workmen's Compensation Policy or Workmen's Compensation Act. Now the term used is Employees Compensation Policy or Employees Compensation Act. It is renamed. Secondly, wage revision is an important aspect. The compensation amount is arrived at by applying the age and age wages. So as per the recent amendment in 2000, the wage level is increased to the limit of rupees 15,000 per month. Though practically the labor rate is more than this much. Because if you are even looking for a mason or a karigar for construction of a house, you can't find it less than rupees 800 rupees per day or 1,000 rupees per day. In that case, the compensation, the labor rate is more than 15,000 per month. It becomes almost 30,000. But no worry, labor means labor. He will be insured under the policy even if he is earning more than 15,000 per month. The only thing is the difference amount of premium will also be charged on the higher income, more than 15,000 per month. So the liability of the labor will be covered. Now this is the law that as per section 17, the employee has a right to recover the compensation. Section 17 of Employees Compensation Act 1923. This says the worker has a right to claim the compensation from the contractor or employer or organization or principal in case of permanent disability, partial disability or death. So, if anybody is asking for the policy known as the Workmen's Compensation Policy or Employees Compensation Policy, don't get confused, the meaning is same, because both are the same things. Only thing is, this is Employee Compensation Insurance is the new name of the policy. So the object or the purpose of this act and policy is just to provide relief to the workman or their dependent in case of death or disability, due to accident, arising out of and in the course of employment. This is the legal terminology, most important it is. Arising out of and in the course of employment. If it is not in the course of employment, if it is out of the course of employment, the employer or the contractor is not liable. Say suppose the factory is working Monday to Saturday. If the workers suffered a disability or an accident on Sunday, which is a holiday, employer is not responsible for that. But if he suffered accident on Tuesday or Wednesday during the working hours, during the course of employment, then the employer is responsible. So this phrase is very important, arising out of and in the course of employment. Now, what are the circumstances where the responsibility of employer is there? Maybe because of the personal negligence of the employer himself, personal negligence of employees, negligence of fellow employees, breach of statutory regulations. Say for example, violation of Factory Act, failure to provide safe place of work by the employer. These are the different circumstances where a worker or a laborer can suffer the injury or disability or death. But they all circumstances lead to the financial compensation to the worker or in case of death to the dependents. It should be accidental. This is important. It should not be intentional, it should not be deliberate, it should not be willful. Accidental. Accidental means any event which is neither expected nor designed. Accidental means something which cannot be pre-planned in the course of employment. This indicates the time when the injury is caused. Suppose the injury is suffered in midnight during the working days, but at the midnight when he is not working, he is out of the office or out of the site. This is not the responsibility of the employers. Now, out of employment refers and establishes the casual connection between the injury and the employment. So these three terms are very important. It should be accidental, it should be in the course of employment, it should not be out of employment. Now, what is the liability covered under the Act? Only these 5 liabilities are covered and nothing else. The responsibility of the employer is to pay the compensation if the worker or the laborer or the employee has suffered death, permanent total disability, permanent partial disability, temporary disability, whether total or partial, and the occupational disease. This occupational disease, some companies are covering in the basic coverage, some are provided as an add-on coverage, maybe charging the additional fee for that. But this is part of the policy. So this is the only coverage. Now when you are selling this policy to anyone, any contractor or employer, you will face 2 questions only. The first one, how you will calculate the premium of the policy, because the nature of calculation of premium of this policy is absolutely different. And secondly, how you will calculate the amount of compensation, because the claim amount or the amount of compensation is again different. There is no surveyor is required, no investigator is required for that purpose, because the amount is already calculated. That is as per law. That has to be paid. But how that is arrived at, that is important. So let us see the first question. How the premium of the policy will be calculated. So to calculate the premium of this policy, you need 4 things. And all the 4 things are important. You cannot miss even a single out of 4. But these 4 things are: First, number of employees or the workers or the laborers. They are part of the PM calculation. Secondly, the wages or the salary of these workers per month. Maybe the worker is engaged on the HADI or daily wages system. You can calculate in terms of monthly wages. What is the period of insurance required? Number of months. Maybe 6 months, 9 months, 12 months. If it is more than 12 months, then the person will be renewed annually. And the nature of work. Nature of work is important because the premium will be applicable on the nature of work only. But to apply the premium, all these 4 things are required. Suppose the proposer is giving you the detail of all the 4. Still, how will you calculate the premium? So first 3 things have to be multiplied. Number of employees into salary of the workers into period of insurance, whatever sum is arrived at. On that, the premium rate is applied according to the tariff. Tariff provides the premium rates. Workmen's compensation tariff is there. Though the tariffs are different, but the basic concept is the same. You take the rates and whatever your company authorizes, you give the discount on that. Because the rating structure is very scientific. According to the nature of work, the premium rates are decided. So rating depends on the nature of work. Nature of work has to be disclosed by the proposer. And it could be in any form, because the labor is engaged in all kinds of works. Maybe civil construction, maybe farming, maybe factory, manufacturing unit, whatever it is. Even for shops, the labor is required. So all these 4 things are required to calculate the PM. First 3 things will be multiplied, number of employees, salary of these employees, and period of insurance. And then the rate will apply on the sum arrived at according to the nature of work. Now the question is, this nature of work may differ because the PM rates are given in tariff per meeting. And if it is the monthly wages more than 15,000 rupees per month, means more than 1,80,000 annually. So on the upper part means that excess amount, premium shall be calculated at 61.4% of the book rate, subject to minimum rate of ₹2 per milli per annum. So even if the wages is high, still the worker can be insured. But rate will be applicable as per the nature of work. This is the kind of tariff given. Rate per milli and nature of work is defined. Say suppose I have agricultural farm. I have 10 laborers who are engaged in agriculture. Now I know the legal responsibility of mine. If during the working hours they are working an entire day in the farmhouse, if anything happens to them due to any accident, this is my responsibility to pay the compensation. If anybody dies during the working hours, it is my responsibility to pay the compensation to their dependents. So I don't want to afford this liability, and I am taking insurance policy to transfer this liability on the insurance company. And to take the policy, I just have to pay the PM at the rate of 5.85 per thousand. But what? 5.85 per thousand on what? On this sum. Number of workers, 10. Salary of these workers, say suppose I am paying 12,000 rupees per worker. So this is the wages. Period of insurance maybe for 1 year, 12 months. These 3 are multiplied, and on that sum I will apply the rate of 5.85 per thousand. This is the simple way of calculating the PM. If the organizer is the big one, say suppose a factory there, factory of say aerated water manufacturing is there. Some around 200 workers are there. Out of that, only 40 workers are skilled workers and 160 are the manual laborers. So the salary will differ. For skilled workers, maybe the salary is 15,000 per month. For manual laborers, maybe 10,000, 12,000. So the entire 200 workers will be included, multiplied with the wages payable to them, multiplied with the wages payable to them, and then the period of insurance that is required for 1 year. On that sum, the rate of 15.10 per thousand will apply. So this is the simple way of calculating the premium, and then you are arriving at the basic premium. But thereafter, we have got three extensions, three add-on covers. The first one is very important, that medical expenses. So this medical expenses is as per the choice of the proposer. Because there is a table which provides that the medical expenses limit can be selected by the proposer. A policy may be extended on the following scale to provide for the payment of medical and surgical and hospital expenses. Limit has to be selected by the proposer. Limit may be 5,000 rupees per year, 1 lakh rupees per year, 5 lakh rupees per year, or even the actual medical expenses. If the actual medical expenses limit is selected, then the additional premium payable is 150% of the basic rate, subject to minimum of 700 rupees per person. And if they only the 5,000 rupees per year or per policy year is selected, for that the premium payable is only 30%, subject to minimum of 80 rupees per person. So this is optional. But surprisingly, this can exceed, depending on the number of laborers covered, the basic premium of the policy. Because the premium rate and because of the number of workers. Both are important aspects and both are part of premium calculation. So this is the first one, medical expenses, which must be advised to the proposer that you should select it. This is not covered in the policy. You may be misunderstood. You may be misunderstanding if you presume that the medical expenses will be paid by the insurance company. Unless you are selecting, you are paying an additional premium, nothing will be paid as medical expenses. Only the compensation will be paid for the death, for the PTD, for the temporary total disablement, and for the partial disablement. Second one is extension for compensation for occupational disease. In our policy, this is second add-on. For this one, the 50% of the rate is applicable. But it is important to understand what does occupational disease means, how it can become. You must have seen in factories, workers are engaged in a similar kind of job for a couple of years. Say suppose a worker is a welder. He will do welding throughout his life in that factory. If he is doing the welding continuously for some 7, 8, 10, 15 years, the probable danger to his body part is loss of eyesight. So the eyesight may be lost. There are certain occupations which are resulting in certain kind of diseases. Maybe like the skin disease, hearing impairment, lung cancer, infections due to contamination, loss of eyesight, because they are related to the nature of work. If they are not doing this kind of work or this nature of work, they may not be suffering. So sometimes some workers are working on a furnace. So all the time they are engaged on furnace. They must be inhaling the smoke all the time. They may suffer with the bronchitis or asthma. Why? Because this is the nature of work. So this is an occupational disease. This kind of diseases should be covered. Third one is insures liability for contractors or subcontractors, employees. Sometimes what happens, suppose I am a contractor. I have one project site. I am engaged with my 50 laborers. After 3 months, I got one more site. So for that another site, I have got one subcontractor. He has also engaged 25 workers. Now, sir, I am responsible for both the sites. I propose to the insurance company that cover my subcontractor as well as 25 employees also. They are working on the different product sites. This is their address and location. In the same policy, they can be covered. The only thing the insurance company will need is the proposer has to disclose the correct wages and correct the number of workers, because both are the part of the premium calculation. Number of workers as well as correct wages. So contractor or subcontractor should not hide this detail, because maybe at the time of insurance the company is not asking for any documentary evidence. But at the time of settling the claim, the company will definitely ask for the wage register, for the muster roll, and that will prove the correct position. So at that time, if it is found that the detail given was not correct or false, or something was concealed, or some misrepresentation was given, in that case, ball is in the court of insurance company. They may reject the liability. Reputation of a claim is very simple if the contradiction of the facts is there. If the insured has misrepresented or concealed this fact and not disclosed the correct particulars, this is the legal right of the insurance company to repudiate the liability. That means there is no fun of breaking the policy if the correct detail is not given. So this should not be done. So now, after the calculation of basic premium, once the basic premium is calculated and the premium is added on account of medical expenses, if this government cover is taken, occupational disease as well as the liability of subcontractors, this is the choice of the proposer. If he wants, he can take all the three, he can take one, or he should not take any one. This is his choice. So after basic premium, this is added, and that is how the premium of the policy is calculated. So first part is over. Coming to the second part, how the claim is settled. So to settle the claim, insurance company will ask for three things: nature of injury, or the disability, or the death. Secondly, monthly wages of the workman. And then the insurance company will apply the relevant factor. Now, what does relevant factor mean? That's okay. So the relevant factor is given already. Is it now? Okay. Will I continue? So the amount of compensation depends upon three things: nature of injury, monthly wages, and the relevant factor. Nature of injury means what the worker has suffered: injury, disability, or death, to whom the compensation has to be paid. Secondly, what he was earning at the time of that incident. And third is relevant factor. So this relevant factor is specified in the Schedule 4 of the Working Tariff as well as Act. Relevant factor is how the amount of compensation shall be decided, that I have shown you just now. But an important aspect is there is no distinction between an adult and a minor worker with respect to the amount of compensation. This is a legal terminology. This is the worker may be less than 18 years. The worker may be more than 60 years. If the employer has engaged him, he is responsible for that. If the worker has suffered any injury or disability or death, the compensation has to be paid. Law will take the action why he has engaged the person of more than 70 years or less than 18 years. That is another factor. Insurance company is not concerned with that. Law is absolutely clear. Law says that there is no distinction between an adult and a minor worker with respect to the amount of compensation. Once if the worker has suffered due to accident, during the course of employment, any injury, any disability or death, he or his dependents are entitled for the payment of compensation. Now, nature of injury can be explained. What the worker has suffered. Monthly wages, the employer will provide. Relevant factor. This is not duty of the worker or the employer to provide the relevant factor. It is already available. How it is available? This is given in Schedule 4. What is this? This is an example given in case of the death of a worker. This is calculated on the basis of the age. It starts from 60 to 65. If the worker is of 14 years or 15 years, this 16 years factor will apply. If the worker is of 70 years or 75 years, this factor of 65 will apply. That means, according to age, the compensation is decided. And according to wages, the compensation is decided. Say, suppose the worker was getting 15,000 rupees per month at the time of death due to road accident. Yeah. That's what I just explained. This is the provision, legal provision. There is no distinction between an adult and a minor worker with respect to the amount of compensation. Maybe the legal action may be there against the employer, but the insurance company is not concerned with that. Insurance company will pay the compensation. If the law is imposing any penalty or the fine, employer will pay it. Why he has engaged against the provisions of the law the person of less than 18 years? For that the employer is responsible. What if he has engaged and during the course of employment the worker has suffered any injury or death or disability? He cannot escape the liability. He has to pay the compensation according to the provisions of the Act. Now suppose on this ground they cannot. On this ground they cannot. If the worker is less than 18 years of age, on this ground the WC compensation they cannot. For any other policy it is applicable. For any other policy, even for motor policy it is applicable. But for this policy, because the Act permits, there is no distinction according to age. So for this policy only, this is a social security legislation. So the object is different. The family of workers should not suffer. That is the reason. And the compensation is decided in the manner that lower is the age, higher is the compensation. Higher is the age, lower is the compensation. In case of worker, in case of death, suppose the wages is 15,000 rupees per month, the highest amount will be paid to the lowest age of the worker. Say suppose 16 years was the age, factor is 228.54 and the amount payable is 17,14,050. This is the highest amount payable in case of death of a worker. It cannot be more than this under any circumstances across India with any insurance company under the provisions of the law. So this is the highest amount, but the compensation will be paid according to the age of the worker. Say suppose the age of the worker is 30 and wage is paid to him was 15,000. During the working hours he died due to accident. So the relevant factor would be 207.98. And according to the wages of 15,000, the compensation payment would be 15,59,800. So obviously this is less than this one. Age will decide how much compensation is payable. Age and wage combinedly make the relevant factor. This is in case of death only. Another case is of permanent total disability. In permanent total disability, the compensation would be higher. Obviously, a question comes into the mind: why it is higher? Why not in case of death it is higher? In case of death, the compensation is paid to the dependents of the worker because the worker is no more. So this is one-time compensation paid. One in case of permanent total disability, the worker is also alive. He is not able to work because he has lost the body parts, and his family is also dependent upon him. So the amount of compensation would be little higher. Here, the maximum compensation payable for a person of 16 years who has suffered a permanent total disability. What is permanent total disability? I will explain in next slides. He has suffered the permanent total disability according to the medical certificate of the doctors. In case the relevant factor is same 228.54, but the amount of compensation would be 20,56,860 for the same worker who is getting 15,000 rupees per month. Difference is understandable. In case of death, it is 17,14,000. In case of permanent total disability, it is 20,56,000. Principle is the same. Lower is the age, higher is the awarded amount. Higher is the age, lower is the amount. Age and wages will decide the amount of compensation according to the nature of injury. Nature of injury could be death, permanent total disability, permanent partial disability, temporary total disability. It depends. But how we will understand? On the basis of the medical certificate. Whatever the doctor is certifying, we have to trust on it. Because the claimant will submit us the medical report. Only on that basis the amount of compensation will be decided. Now, suppose there is a case of death. Now, how the compensation will be calculated? Here the formula is 50% of the monthly wages of the deceased in case of death, multiplied with the relevant factor. Now, but under no circumstances it can be less than 1,20,000. It has to be, if the amount comes is higher, the higher amount will be paid, whichever is more. Whichever is more, because this is social security legislation. Normally in insurance policies you will find whichever is lower, whichever is less. But this is one policy where you will find whichever is more. Formula is 50% of the monthly wages. In case of permanent total disablement, the compensation amount has to be a little higher. Here it is 60% of the monthly wages, multiplied with the relevant factor. But under no circumstances of permanent total disablement, the amount of compensation could be less than 1,40,000. In case of death, it was 1,20,000. In PTD, it is 1,40,000. Here again, whichever is more. Permanent total disablement. What is this? Means if a worker due to accident has suffered something like loss of limbs, loss of eyesight, paralysis, doctor has certified yes, this will come under the category of permanent total disablement. And for permanent total disablement, 100% compensation is paid. Let us see a practical example, how the amount will be calculated. Suppose in my factory, a worker of the age of 46 years died due to accident. He was getting the salary of 15,000 per month at that time. Now the compensation has to be paid to his family. How the amount shall be calculated? Completed age is 46 years. Relevant factor table says for 46 years, the relevant factor is 166.29. And in case the wage is 15,000, the amount is 12,70,800. Sorry, 12,47,175. 46. So simple to calculate. Simple to calculate. How it will be calculated? The amount shall be calculated like this. Completed age 46 years. Relevant factor 166.29. 50% of the death of the wages. 50% means 7,500. 7,500 multiplied with 166.29. Amount of calculation 12,47,175. Same amount was there in the relevant factor table. So here, this amount is more than 1,20,000. So this amount will be paid as a compensation. And in case of death, maximum compensation payable is only 17.14 lakh. It cannot be more than this. In case of permanent total disablement, the compensation would be maximum 20,56,860. It cannot be more than this. Take another example. Suppose I have a shop. I have a servant for opening the shop, or closing the shop, or for cleaning, etc. 30 years of age. I am paying only 3,000 per month. He died due to accident during the working hours. How the compensation will be paid to his family? 3,000 only the workers' labor, workers' wages. So 50% of it means 1,500. At the age of 30, the relevant factor is 207.98. So 1,500 multiplied with 207.98, the amount comes 3,11,970. Since this is more than 1,20,000, this amount will be paid. Another factor, suppose the person has not died, he has suffered the permanent total disability. That means he has lost both the eyesight, or both the hands, or both the legs. So this 50 will become 860. That's all. 60 means 1800 into 207.98. Whatever amount comes, that will be paid. Simple calculation. So what you need is nature of injury, monthly wages of the workman, and their relevant factor. And there is no distinction between an adult and a minor worker. Maximum and minimum limits are decided. In case of death, the compensation amount cannot be more less than 1,20,000. Whatever comes more than 1,20,000 is payable. 50% is the formula. PTD 60% is the formula. Minimum payable is 1,40,000. Permanent partial disablement, whatever percentage is certified by the medical doctor, that percentage payable. In permanent total disablement, these are the categories where the 100% compensation is payable. Loss of both the eyes, loss of both the hands, loss of both the legs, absolute deafness, very severe disfigurement, complete paralysis of the body, like that. Partial disablement means, suppose one eye is lost, back injury is there, loss of speech is there. Here the doctor will certify what is the percentage of permanent disability. Compensation for permanent partial disability is according to the medical report. It could be 95%, it could be 5% only. Say suppose amputation of both feet resulting in hand wearing stumps, 90%. This is medical terminology, we are not concerned with it, we will go for certificate only. Or say suppose this one phalanx of the finger is lost, 9%. So whatever percentage is certified by the doctor, we will pay that. Compensation to be deposited with the Commissioner of Workmen Compensation, because he is the authority and he will issue the proof of discharge of the employer's liability. Temporary disablement. Temporary disablement means where the injury is recoverable. Maybe the person has suffered two severe fractures. For 3 months he was on the bed. So for that period, if the medical expenses are obtained, medical expenses is payable. But the compensation would be according to the 25% of the monthly wages of the employee. This payment will continue till the treatment is continued. Mode of payment would be by check only. The commissioner has got the authority to impose even the rate of interest if the payment is not made in time. Now this is the premium calculator provided to you and your branches. Here the premium calculation is very simple. But this policy has certain restrictions. Any injury which does not result in fatality, means death or partial disablement for a period exceeding 3 days is not covered. Suppose some injury is there, within 3 days it is okay, nothing. First 3 days of disablement where the total disablement is less than 28 days is not paid. Otherwise everything is paid. Except that the worker is not under the influence of drinks or drugs. He has not willfully disobeyed. He has not willfully removed or disregard the safety guards. One more important exclusion is, if the policy, if the liability is covered under any other policy, this will not be paid. So 3 important exclusions are drink and drugs, disobedience and disregard. Disobedience means employer has assigned some other duty, worker was doing some other duty with his own will. Disregard means, suppose the factory worker is engaged in coal mines. Employer has provided the safety hat, safety shoes, torch, gloves, but he is not using and he has suffered injuries. Employer will say, I am not responsible, it is your negligence. In that case, the insurance company will also not pay the compensation. One most important factor is natural death is not covered. Natural death of a worker is not covered. Natural death is not covered under any of the general insurance policies, because natural death is insured only under the life insurance policies. So this policy is applicable for the social compensation, but if the employer has taken a group PA, in that case again, the entitlement of the worker is there to get the compensation. Because group PA is not a statutory policy. Their premium calculation, their payment of compensation, all things are different. Group PA is applicable for 24 hours, worldwide. So that coverage is absolutely different. That will not make any impact on the compensation payable under the WC policy. You must know this factor that our company all companies are having their decline list. Decline list means factors which are contributing more losses. So in your case, if the worker is engaged in mortar forges or boundaries, blasting and tunneling operations, chemical industries, any location which is surrounded with the water, or at a abnormal heights, the proposal will not be accepted. And the important aspect is an employee covered under ESI is not to be covered under WC insurance because the benefit payable are almost similar. If the ESI benefit is payable, then WC policy is not required. At the time of claim, the insurance company will ask for the documents, medical certificate, wage statement, proof of age, claim form, detailed version of the incident. And since the accidental liability is covered, FIR, Panchnama and MLCA are also required. If the award is issued by the commissioner, that has to be honored. So this policy is most relevant because without making your any effort, the people can contact you for cutting this policy. Why? Because certain employers, when they are inviting tenders, they have their condition in the tender application that the contractor will submit an insurance policy for the like amount. So this policy can be taken by contractors, labor contractors, shops, factories, labor associations, factory inspectors. They are all asking for this policy. If the worker has claimed the compensation under any other code, then the provisions of this code will not apply. This is normally happening where the worker is working on a vehicle, say loader, unloader, cleaner, conductor. When they are meeting with an accident, they are claiming the compensation in MACT, Motor Accident Claim Tribunal. While they have got a right to claim from the Commissioner of Workmen Compensation also, but in either code. If they are claiming the compensation from MACT, they will cannot claim from here. Another factor is the period to lodge complaint is normally 2 years. Top 5 injuries which are noticed: strain, cuts, contusions, bruises, inflammations, fractures. These are normal. So this is the WC policy. If you have any doubts, any clarifications, you can just ask. Yeah. Yes, repeat. If yes.